situation of me trying to get into the courtroom. Mr. Burleson mentioned outside just a moment ago he was happy for us to be back in court. Some things change in 2 years, and the door has changed. You have to know how to get in now. And
I don't want to take a lot of credit, but I'm the one who had to figure out how to open the door. But I don't want to cast any shadows.
And perhaps that should give you some indication of how things are going to go this morning. But anyway, I wanted to thank Judge Clement and follow up on what he said. The Court of Appeals is one court, and we have judges who travel and who join with us on occasion, and we thank Judge Clement for getting up and coming from Nashville and joining us this morning. It's always a pleasure to have him, and it's always an entertaining time. So thank you, Judge Clement.
Thank you. All right, are there any announcements? Hearing none, please call the first case.
Dr. Rolland W. Pack et al. Versus Freed-Hardeman University.
Good morning.
Good morning, Your Honors. I'd like to reserve 3 minutes for rebuttal.
3 minutes, certainly.
And my next question was going to be whether I have to figure out the clock, but it appears
The clock should be programmed at 12, and if you exceed your time, the trap door opens and you fall through the floor. So,
or throw something.
okay.
May it please the court, my name is Clint Scott, and I represent Dr. Rolland Pack and Dr. Jerry Thornthwaite in a breach of contract action against Freed-Hardeman University. Dr. Pack was a tenured professor at Freed-Hardeman, obtained tenure in 1997. Dr. Thornthwaite.
Are you sharing time for your argument, or are you doing all 15 minutes?
I'm doing it all, Your Honor.
Very good, thank you. Okay.
Dr. Thornthwaite was awarded tenure in 2004. Tenure at Freed-Hardeman University, being a private institution, is governed by Tennessee contract law. Under Tennessee contract law and the facts of this case, the contract consists of a few different things. One, the tenure letter, the offer of tenure by Freed-Hardeman University. Freed-Hardeman then drafts policies and procedures that govern the tenure relationship. And finally, pursuant to those policies and procedures, each tenured professor receives an annual contract each and every year. That annual contract goes for the academic calendar year. The faculty at Freed-Hardeman consists of tenured and non-tenured faculty. And there's one striking difference in tenured and non-tenured, as you can imagine. A tenured professor is guaranteed to receive an annual contract each and every year going forward, except in very few limited circumstances. Conversely, non-tenured faculty are not guaranteed to receive an annual contract each and every year. In fact, the Freed-Hardeman policies specifically state that a non-tenured faculty member can be notified by January 15th of the year that they will not receive a contract the following year. That's all there is to it. There's no contractual obligation for Freed-Hardeman to non-tenured individuals moving into the next academic year, so long as they notify them by January 15th.
In this case, there's no question about notice. It's just the two grounds. Is that right?
Yes, Your Honor. Notice is not an issue. We did receive notice in November of 2013. The trial exhibit is Exhibit 8 for that provision that says that you must get your non-tenured faculty don't have to be notified until January 15th. So that moves us to the next policy, non-renewal termination of appointment, which is how a tenured faculty member can be terminated at Freed-Hardeman. There's two ways. One would be with cause. There's no dispute in this case that the terminations of Dr. Pack and Thornthwaite were without cause. Nobody says they were terminated for cause. Without cause, Freed-Hardeman does have the ability to terminate employment if there is financial distress or a bona fide program reduction. Freed-Hardeman wrote this policy, issued this policy, and must live with this policy. But when there is a without cause termination for bona fide program reduction or financial distress, Freed-Hardeman is required, if for the reasons stated above, financial distress or bona fide program reduction, it specifically states the institution will consider placing affected faculty members in other available and suitable positions. Such positions may not carry the same compensation and other terms of employment. In other words, it specifically is designed, the policy, to apply when there is financial distress, that FHU will make this consideration and they no longer have to give the same title, same type of hours, or the same compensation to a tenured employee going forward. It is mandatory, not discretionary. Will consider. In November of 2013, Freed-Hardeman provided letters to Dr. Pack and Thornthwaite. Those letters indicate that they will not receive an annual contract, and this is important, for the 2014-2015 year, academic year. So we're in November of 2013. We're in the 2013-2014 academic year. They already have contracts for that year, Drs. Pack and Thornthwaite. Says we will not be giving you an annual contract the following year. So here, in this case, Freed-Hardeman, if they're in financial distress and a bona fide program reduction, they still have to consider whether they will place them, Dr. Pack and Thornthwaite, in available and suitable positions. We do not have to reach the issue of whether there was actually a bona fide program reduction or whether there was actually financial distress. Instead, the issue is decided solely on whether or not Freed-Hardeman considered. And let's talk about that. Freed-Hardeman admits that it did not consider. There's affidavit of Dr. Davis, Dean Davis, and Dean Smith, trial exhibits 23 and 24. I did not consider what other courses Dr. Pack or Dr. Thornthwaite may teach. Same language for Dean Smith. I did not consider what other courses Dr. Pack or Dr. Thornthwaite may be able to teach. The policy says will, and they did not do so. The claim is that they didn't have to because of financial distress. That's not right.
Are there any parameters on those other options
Parameters,
as to how much or how far down the line the university has to look?
university did not specify that in their policy. It's the position of the appellants here that it is for the 2014-2015 school year, because Dr. Pack and Dr. Thornthwaite already have contracts for the 2013-2014 school year.
Well, let me be more specific. Do we have to only look at teaching positions, or are there other options, administrative positions, or maintenance positions, or what?
Judge Stafford, I believe that the university has to look at all positions. If it wanted to limit that to something more specific, then Freed-Hardeman would have had to have written that in their policy. It says available and suitable positions. And here, Drs. Pack and Dr. Thornthwaite were not considered for those positions whatsoever. So it could have been a teaching position, could have been an adjunct position, could have been an administrative assistant. And all Freed-Hardeman had to do was to consider it, but they didn't. Instead, they relied on the fact that they were in financial distress. But the very policy that provides for this consideration, that we will consider, says that we do it in times of financial distress terminations. You can't put this language that we're going to consider whether to place you in another available position at a time of financial distress in your policy and then say, well, we were in financial distress, so that alleviates our obligation to do that. That would render the entire provision meaningless. And importantly, it says that it doesn't have to carry the same compensation. So it gives FHU the ability to avoid the financial impacts by saying, hey, we have an adjunct position that's going to teach 3 hours. You're going to make $10,000 a year. Freed-Hardeman saves money. And a tenured professor that has the rights of a tenured professor gets to continue their employment. But Freed-Hardeman never even went through those steps.
Let me ask you, counsel, in terms of the issues raised in your appeal, did you raise that specifically as an issue in your appeal?
Yes, Your Honor.
And you said, now, as I read your issues in your appeal, you talk about a breach of the contract. I don't really see anything where you specifically state that the failure to consider them for a lesser position was an issue on appeal.
Well, the failure to consider any position, which would include a lesser position, is an issue on appeal. They didn't consider any position whatsoever when making this determination. And so,
This is not a quote, but I made a note to myself saying the trial court found the defendant did not breach its obligation to consider placing the affected faculty member in other suitable positions because the administration determined that there were no other available and suitable positions. So are you saying that there is no evidence, whether it preponderates in favor of or not, but just no evidence to support that finding?
yes, Your Honor, I am. There is no evidence to support that finding. The evidence or the ruling made by Chancellor Jimmy Butler was based upon the testimony that due to financial distress, they said our operating budgets, there were no positions for us to consider. But that's not what the policy says. The policy says that we will consider whether there's an available position or not. And as of that point in November of 2013, every single position, non-tenured position for the 2014-15 calendar year, the first calendar year that Dr. Pack and Dr. Thornthwaite did not receive annual contracts. That following year, remember they have a contract at the time they're notified that they're not going to get this. Every single non-faculty member position, non-tenured faculty was available. Freed-Hardeman had not contractually obligated itself to fill any of those positions with anyone. And there's an important fact here. At the time that Freed-Hardeman was making this determination that we're going to terminate you, they're specifically contemplating going to hire an adjunct professor in the fall of 2014 to teach Dr. Thornthwaite's labs.
Let me ask you a quick question before your time runs out. You quoted the affidavits of two individuals, but isn't it the board who actually makes the decision about the termination and the other available options?
It is not at Freed-Hardeman. It is not.
How does that work?
The testimony at trial court level is that President Wiley instructed Charles Virus, the academic vice president, to make certain cuts. He then went to his deans, who made recommendations that he followed to the letter.
So there's no discretion as far as the board's concerned, or
Correct. The
Okay.
board has no discretion in making the determination.
okay.
Thank you, Mr. Scott. We'll hear more from you on rebuttal.
May it please the court, my name is John Burleson. I'm a member of the Jackson-Madison County Bar. I'm here in representation of Freed-Hardeman University. Your Honors, Chancellor Butler got it right based upon the proof presented at the trial. We spent 3 days trying this case in Chester County with numerous witnesses, the two plaintiffs and numerous university witnesses. Chancellor Butler found correctly that Freed-Hardeman University fulfilled all its contractual obligations to Drs. Pack and Thornthwaite. The record is full of documentation and information that supports the finding that the school was under financial distress. A lot of this record is under seal, as you might understand. That's confidential information. But you'll find in the record that there was the school was in a difficult situation, which was not unique to private universities at that time and even today. Enrollment was declining. It's a tuition-based revenue model. So if your enrollment is down, your revenue is down. But your expenses are still there. You got to pay for the buildings, you got to pay salaries of your staff, so you got declining enrollment, expenses going up. And so to fund that in the operational budget, the school had to draw against its line of credit, and that amount being borrowed every year was going up, and the amount of line of credit was going up, which meant the interest expense went up, which meant the expenses were even higher. So the appellants argue that there was no financial distress by deflecting from the operating budget and looking at the balance sheet, which Freed-Hardeman University's balance sheet is strong when you look at assets, buildings, endowment, the value of those versus the debt. There's a strong ratio there. We agree. There's no factual dispute in terms of on the capital asset side, the school was strong. It was on the operating budget side. That was a continuous struggle and had been for years. And as a matter of fact, this had been going on for years, and in 2009, I believe it was, the school had done a reduction in force at that point in time to try to alleviate the situation. The situation continued until we got to the fall of 2013, and the Board of Trustees, and Judge Stafford, this kind of maybe addresses one of your questions. The Board of Trustees directed the president at the time, Dr. Joe Wiley, to cut expenses. Now, they didn't tell him how to cut expenses or who to cut, and so he advised his leadership team that they were going to wait until the fall of 2013 to see what type of enrollment they had, and the enrollment was down, did not meet projections. So they had to cut expenses, and they had cut all the non-personnel expenses as much as they could. And so Dr. Wiley directed his provost, chief academic officer, to talk to his team, each of the departments and each of the deans, and make proposals to him. And that's what happened here.
So does the board have any discretion in this?
And here's where they had discretion, Your Honor, I think, is that the operational budget is really directed by the president and his team. The board has discretion and does supply some funds on an annual basis out of discretionary funds in the endowment and on the capital side to support the school. But the board is looking at a big picture of the long-term health of the institution, and it's just not, the institution is not going to last long-term if they don't preserve capital. So that was where their discretion was.
So the personnel matters, the decisions about teaching and tenure and all that, that's not really a board decision. That's a university president and the dean's decision.
The specific decision on what positions to cut and who those were going to be, that was on the university, the president and the administrative and the team side. The board would just give a general directive, cut expenses.
So Mr. Scott says that both deans, I assume it was both deans, said in their affidavit that they didn't consider any of these other positions.
Here's what they said, Your Honor. They said that at the point, and it's real important to understand what that condition is in the policy, which is policy 3.2.1.11, which deals with the process the school has to follow to not renew the contract of a tenured professor. Number one, tenure is just within the department. It's not university-wide. That's very important. Number two, what the policy says is before termination, the school has to consider what's suitable and available. Now, to address your question, the affidavit, Dr. Leanne Self-Davis is one, and then Dr. Billy Smith. She was the dean of still is dean of the School of Arts and Sciences, Dr. Billy Smith School of Biblical Studies. What they said was, we've been directed to cut positions. And so before termination, which was in the fall of 2013, they had to determine if there were any suitable or available positions. Well, they were cutting positions. There were no open positions there. It's a small school.
Were there any non-tenured positions available in each department?
No, sir, there were not. And again, the timing.
Okay, let me clarify. So
Yes,
what
sir.
you're saying is the only teacher positions in either of these two departments, all of them were tenured?
No, I'm not saying they're tenured. I'm saying there were no open positions.
Okay, well, were some of those unopened positions non-tenured?
Yes, they were.
Then if you have a tenured teacher who has a right to be considered to be placed in other suitable and available positions, why wouldn't the tenured teacher have a priority over a non-tenured teacher?
Here's why, Your Honor. Number one, it's what was suitable and available at the time they were making the decision.
Okay,
And
if it's in the same department, why wouldn't that be suitable?
there's evidence in the record as to the analysis that the dean of each of these schools went through. Again, it's a small department. Let me give you, for example, on Dr. Thornthwaite.
Okay, I'm not interested in the small. Was there a non-tenured position, let's say, in the religion department?
There was, Your Honor, but
Okay, then why wasn't this tenured teacher considered for that position?
because there was no position available at that time. They
It
were
could
all
have
under
become
contract.
available if the board or the president had made it available,
But
because it was a non-tenured teacher and that person had no right to be employed next year.
But I understand what you're saying, Your Honor, and I think what the policy says is what was available at the time the decision was made. And then-
Well, at the time the decision was made, the non-tenured teacher had not been hired for the next academic school year, had he? Or she?
No, sir, but
Okay.
that would happen in the spring of 2014.
Okay.
And the school did not know what its needs were going to be at the time. And if you look in the record, there's an analysis by the deans of, this is where the smallness of the department comes in. For example, in the chemistry, they merged chemistry and biochemistry. And one person that was kept was non-tenured, but he had a skill teaching in computational chemistry that nobody else in the department had. And what the deans testified is we had to do what was best for the students to protect the school so that a student that wants to get a chemistry major here at Freed-Hardeman is going to be covered. And there was a tenured professor who had analytical chemistry skills that nobody else had that could offer. Dr. Thornthwaite did not have that. So the dean went through an analysis of what can we do with these limited resources and basically have people cross-trained who could handle what we needed to handle. And for example, they had people in biology.
So you're relying upon the suitable
Yes, sir.
factor, okay, as opposed to available.
Well, no, sir, I'm really applying, I'm on both, available and suitable, because there were no positions available in the fall of 2013. Everybody was under contract.
Well, but they would have been available for 2014,
But-
and that's when this tenured teacher was hoping to be employed.
I understand that, Your Honor, but that's not what the policy says. The policy says before termination, you've got to consider what's suitable and available. That was in the fall of 2013.
Termination.
And so they didn't know what they were going to need for the next academic year, and so
Okay,
they had to make
When
a
does termination become effective? When the school notifies the tenured teacher, or when that contract terminates?
I think when they notified them.
And why do you say that?
But, well, they no longer taught there. They did continue to pay off.
No, they continue to teach there for another academic year.
No, sir, they did not.
Aren't they notified at the beginning of the 2013 year that they will not be under contract in 2014?
Yes, but they
Okay,
were,
then isn't there a full academic year before the termination takes effect?
no, sir. Their teaching duties
Are they
ceased.
receiving a paycheck each month?
They did receive a
Okay,
paycheck.
but you're paying them after they're terminated.
Yeah, correct. They were terminated on November the 18th.
But they're still showing up for work because they're under contract to work.
No, sir. They did not work anymore after November 18th, 2013. They did not teach anymore. They did not work anymore.
When
They
did
were
when
paid
did the academic year begin?
in the fall, like August or September of 2013.
Okay, and that's when they were notified.
Well, they were notified in November of 2013, and it was effective immediately.
So
did
they were
not-
notified at the end of the academic year. that they would not be hired the next academic year.
They were notified in November of 2013 that they wouldn't be hired for the 2014-2015
Which
year.
begins when?
In August of 2014.
Okay, and did they teach in January, February, March, April?
No, sir, they did not.
So they only taught in the fall?
They didn't even finish the fall semester. Their last day was November 18th, 2013, the day they got their notice.
Okay, all right.
Well, let me follow up on something Judge Clement opened the door on. They're terminated, or they're effectively terminated in November of 2013. They're paid through the end of the academic year.
Right.
From the perspective of the appellants in this case, when you're required to consider these other options, what is the window of time that you're required to consider it? Is it the time of termination, or is it any time that, or any position that becomes available before the time their contract expires?
Let me, Your Honor, I think the way the policy is worded, it says it's before termination, which would have been before November 18th, 2013. That's what Freed-Hardeman did. They assessed the situation they had at that point, said we don't have anything available, and so there's nothing suitable if you don't have anything available.
But suppose they've got an adjunct position that becomes available January 2014. Do they have any requirement to offer that adjunct position to one of the appellants?
No, but they do have an obligation to offer them. If they can't fill the tenured position. In other words, a full-time position, they can't fill that. And the point was they were trying to eliminate a full-time position, actually 1.5 in the chemistry or arts and sciences, and then 1.5 in the School of Biblical Studies. And so the point is they were trying to reduce the number of employees, the number of faculty they had, because they had less students and less need. And that's why they had to go through the analysis of, could they cover what their students needed with the faculty they had? And I explained in chemistry what happened. In the biblical studies, for example, they did hire an adjunct for a part-time position, but he had expertise in biblical languages, Greek and Hebrew, which Dr. Pack did not have. So they were being strategic in what they were doing to try to utilize their resources the best they could, trying to fulfill the directive they received from the board.
Well, okay. Judge Armstrong asked Mr. Scott about this issue being specifically raised in this appeal. Was this issue litigated in the trial court?
There was proof on it, Your Honor. Yes, there was.
Okay. Okay, and so what we're talking about will be found in the record?
I think it will, Your Honor. I think, be frank with you, I don't think there's a whole lot of factual dispute in this case. I think it's more how the facts are applied and what the determination is. I mean, the policies are what they are, the timeline is what it is, and the interpretation, I guess, is where the magic elixir is. But, Your Honors, I think...
Let me ask you one other question.
Sure.
So the legal significance of the phrase "will consider these other options," that was litigated in the trial court?
There was proof about what happened, yes.
Did the trial court, was it required to render an opinion upon that specific issue?
Chancellor Butler did.
Okay.
He found that the school complied with that provision of the policy. And that's, I guess, to me, one of the important things is Chancellor Butler heard 3 days of testimony. He heard these witnesses. He considered, I forget how many exhibits it was, probably close to 100. And I think he correctly ruled that this contract was complied with.
Yeah, let me ask you, at the time of Dr. Thornlake's termination, how many non-tenured positions were there in the department where you worked?
One is my recollection, Your Honor. It was a Mr. Jim Barr, who was a specialist in, I believe it was computational chemistry. There were three professors that remained after Dr. Thornthwaite.
And how many of those were tenured?
I'm going from memory, Your Honor, but I believe it was 2.
All right, thank you, Mr. Burleson.
Thank you.
Mr. Scott, your rebuttal.
Thank you, Your Honors. A few quick points. The issue is not whether there were available positions in the fall of 2013. Everybody was already under contract. Dr. Thornthwaite and Dr. Pack had contracts for the 2013-2014 academic year. That's why they were paid through the end of that contract. Where they need employment,
Now, you say they were paid through the end of the, when did that contract end?
May
Of 2014?
14.
Now, I understood Mr. Burleson to say their last day to work was November the 18th, 2013. So how can those two both jive?
The university made the decision, despite its financial distress, that they were going to pay them not to work.
So they literally quit working on the 18th of November of 2013, but they were paid under the contract that continued through May of 2014.
Right.
So from your perspective, the contract terminated in May of 2014.
Right, Your Honor.
All right.
Contract couldn't be terminated. It would have been, if they stopped paying them, would have been a breach of that contract. And the letters specifically state that they will not be getting annual contracts for the 2014-2015 school year. Exhibit number 16 and 17. This is to notify you of the elimination of your tenured full-time faculty appointment effective with the 2014-2015 fiscal year. I think that clarifies when the termination. The elimination of your full-time faculty appointment effective with the 2014-2015 fiscal year. It's the same language in Exhibits 16 and 17 from the trial court that are written by C.J. Byers to Dr. Rolland Pack and Dr. Thornthwaite. And so the optimal time frame is, Freed-Hardeman had to consider them for available positions the year that they were no longer going to get contracts, 2014-15. And this is what we know.
Well, let me ask you a question, please, and that is, was this issue presented to the trial court, and what did the trial court rule on that specific issue?
Trial court did not make a specific ruling on that issue. The trial court simply said that they considered available and suitable positions.
So the trial court did not make a determination about what the effective date or the effective date was for the analysis of whether there were other available positions.
That's my recollection, Your Honor.
Okay.
Let me ask you, was there any specific argument at the trial level about at what point you take a snapshot of when positions were going to be available? Mr. Burleson's argues you look at the time they gave the notice of termination. It would seem to me actually, though, if non-tenured teachers had not been notified that their contract was going to be renewed, and they weren't required to get notice until January of the next year, there could have been some non-tenured positions available in the fall of 2014. Is there any language in the contract that your clients had with the university that limited that snapshot look to the date of the termination letter?
No, Your Honor, there is not any language that limits that. It says before terminating for financial distress or bona fide program reduction, we will consider available and suitable positions that may carry different terms of employment and compensation. And that issue was argued and raised at the trial court level.
Okay.
All right, thank you, Mr. Scott and Mr. Burleson, for your arguments. You've given us a lot to think about. We'll take the matter under advisement. Yes, you may. Unless you'd like to hang around and listen to the other